welcome to our broadcast today. My name is Cindy Speaker. I have with me as my guest Attorney Bill Kowalczyk of Michael J. O'Connor and Associates. Bill, nice to have you today.
Hi, Cindy. Looking forward to an interesting conversation.
I am too. Well, we're going to talk today about types of workers' compensation claims.
Okay.
Go
Go ahead.
ahead.
Okay. Now, this subject I decided on because what a lot of people don't understand is there are many and varied workers' compensation claims. The standard claim, man gets injured, obviously goes off work, but it's much more complicated than that. So what questions in particular would you have?
Well, what about, you mentioned the injured worker. What about someone who has a psychological injury? Can that be part of a claim?
Right. So the law does provide for that. Now, what exactly are we talking about? Well, what we see are a lot of different things. For instance, maybe one of the most common would be PTSD, or post-traumatic stress disorder. Yeah. Some people suffer from this as a result of some incident at work. Now, it could be a physical injury or just a traumatic event. I had a particular case that I recall where the individual really didn't get hurt physically, but she was abducted by armed robbers from her place of business.
Oh my goodness.
And put in a car. And the cops eventually arrested them, and she had to testify against them. And the whole thing was very traumatic. She had a gun in her face.
Oh, my word.
Developed post-traumatic stress disorder. So not uncommon for that to happen. Now, the one thing that a lot of people don't know, and this is, again, another thing that I'm going to call unfair about the Workers' Comp Act, is that they differentiate between mental injuries and physical ones. So if you have merely what we call mental case, in other words, the only injury is psychological, then the law puts an additional burden upon you. You can't just come in with a doctor who says, yep, he has PTSD. You have to show that whatever happened at work was an, quote, abnormal working condition. Now, exactly what that means has been defined by cases for years.
Wow.
But recently it's been sort of eroded because, even though an individual may legitimately have a psychological problem as a result of something that happened at work, they can't collect if it's a normal working condition. Some of the most, like say, for instance, a truck driver is in an accident or sees an accident or something. That's normal for that business. There was even a case with a police officer. Police officer is in a gunfight. That's normal. That's a normal. And even though the police officer suffered from PTSD, no doubt legitimately for having bullets whizzing past his ears, there's no collecting because that's what police do.
Wow.
They shoot at people and people shoot back.
Wow.
So anyway, these are some examples, but and so the mental case where there's no physical injury, and sometimes this involves harassment at work.
Okay.
A lot of people work in situations where they're being harassed either sexually or bullied or something, and it just becomes outrageous such that they can't function. Now, you again have to show that was abnormal working condition, because a little harassment at work apparently is normal. But if it's brutal and it's direct and it's usually a supervisor doing it, the courts may find that was abnormal. However, I want to be clear that this issue about having to prove abnormal working condition only occurs when there is just a psychological injury. Okay. If there's a physical injury, we don't have to show that. And I'll give you an example of what I'm talking about. But one of my colleagues, who's a very young and upcoming attorney, tells me that he is going to challenge the constitutionality of this provision because it treats injuries differently. It's an equal
Yeah.
protection problem. So
Yes.
if you get a slice in your arm and you bleed all over the floor, no problem. But if your scarring is emotional,
Yeah.
you have to prove something else. But
Well, you'll have
keep
to
in
keep
mind,
us posted on that. That's interesting.
yeah,
Yeah.
hmm
Yeah.
I find it to be interesting too.
Bill,
So,
what about if the injured worker dies? What happens to that claim?
oh, but before I get into that, why
Oh,
don't
go
I?
ahead.
There's a couple other things I wanted to
Sure.
touch into that occurs to me because what we also see in psychological injuries is they become attached to physical injuries. So you get a bad back, you can't work for 3 years, you get depressed.
Yeah.
I'm going to file for depression. I'm going to try to include that diagnosis in your accepted injury. There's no abnormal working condition requirement there. We just show depression came from injury, and we can do that. And we do that through what is called a review petition. I just wanted to make that distinction because, we're litigating
Yeah.
psychological diagnoses all the time because it's common
It is.
for for someone to get depressed or anxious when they can't work.
Yeah.
Anyway, we
Sure.
see that a
And are
lot.
those cases, do you get favorable decisions on them?
Yeah, almost always.
Excellent.
Um, the judges are willing to believe that a
Yeah.
claimant is suffering. The only exception is there are a lot of people who have a history of psychological problems throughout their life, then they get hurt.
Yeah.
Naturally, that exacerbates it. But often it just looks like the same thing they've suffered from for
Right.
years. That's a tough distinction to make
Okay.
sometimes.
Okay.
But before I cut you off, you were asking me something about death on the job, right?
Right. Yeah.
hmm Right. Of course, this obviously is it's really one of the reasons that the Pennsylvania Workers' Compensation Act was enacted in 1915. Because before then, and these were people working in steel mills and mines, keep in mind in
Yeah.
Pennsylvania. A lot of deaths, a lot of deaths.
Mm.
And where did that leave the widow and children? And nowhere, with no remedy and no help. So in 1915, now we see the Pennsylvania Workers' Comp Act come into effect, and it specifically covers death in the course of one's employment.
Okay.
And of course, all you have to show is that the individual was employed by that particular employer. That individual was working in the course and scope of his employment, and his death was caused by that employment through no particular fault of his own. Now, I'm not saying if an individual is negligent and dies, the widow can't collect. They can. But there are some defenses to this. Obviously, suicide in
Yeah.
the course of employment, that does happen. Or if an individual is not following the rules or is committing a crime. For instance, envision a truck driver who's going 100 miles an hour and blows through a red light, causing his death. They're going to defend that. They're not going to just pay it. But if it's just a regular day on Route 80 and he gets snarled up in traffic and he dies, well, that's a compensable claim.
Yeah.
And I had a really interesting claim we almost took several years ago, but we ended up not taking it. We have an individual, a traveling salesman, who is driving his car down one of the highways, the witnesses say, veered off into a ramp or like a natural dirt ramp in the median strip, goes flying a couple hundred yards or something, lands headfirst, blunt trauma, dies.
Oh my.
Nobody can figure out why. The coroner thought it was suicide.
Oh.
So we knew if we were going to file it,
Yeah.
that we would have to show that it was not suicide. And we didn't think we could do that.
Wow.
And we didn't take it because nobody just veers into the median.
Yeah. Just didn't make sense.
There was no evidence that the car was malfunctioning. But
Yeah.
again,
Yeah.
in that case, the widow is out of luck.
Wow.
So anyway, when the claims are compensable, there are benefits for the funeral and certainly any medical bills that would precede the death. And then there are weekly or biweekly benefits for the widow. And if she
Okay.
has children, she
Yeah.
gets more. Or it could be a widower, doesn't
Yeah.
matter. And in fact, I was just looking at something. They're changing the act because the act has everything in the masculine. They're changing the Workers' Comp Act because obviously it doesn't matter what sex the deceased worker is if he or she is married, that
Yeah.
person.
Sure.
So you get more if you have children. So a widow would be relegated, if she has no children, to 51% of the average weekly wage.
Okay.
Whereas in injury cases, they're generally getting 2/3 or 67%. So the widow gets that amount, but if she has children, she can get more
And
up into the
for how long?
60s. That's a good question. Now, as far as the children are concerned, well, we do know that they're only eligible until the age of 23 at the maximum. But after they turn 18, they have to be enrolled in an accredited college or university to still be eligible for those benefits. If they
Okay.
turn 18 and they go to work, the benefits are going to end. So, needless to say, most of the kids in that category go to college.
Yeah.
It
Right.
certainly makes sense for them to do so.
Yeah. Now, what about the widow? How long can she collect?
Again, good question because there's no real answer here.
Okay.
I have a woman, I believe, who's still collecting widow's benefits, whose husband died in 1980, I think, and
Wow.
she's 85, or
Wow.
but
How
she's still.
about that?
I know, but
So,
here's what happens. The law is that they'll collect indefinitely unless they remarry or unless they are found to be living in a quote meretricious relationship. That's a fancy way of saying shacking up. That's what it is. So anyway, if they
that's
could,
really interesting.
yeah. So if an individual gets remarried,
Yeah.
they get what's called a dowry, which again is also ancient
Oh, that's so
thinking.
funny.
And the dowry is 104 weeks or
Okay.
2 years of benefit.
Okay.
But if they're found to be living in a meretricious relationship, they're not going to get anything. The courts are going to just cut it off. This is very rare
Yeah.
because, as you can expect, it's hard to prove.
Right.
Because not only do you have to prove that the significant other is living there, you have to prove that they're involved in a relationship that is intimate. One of the ways you can do this, and this has happened over the years, a widow gets pregnant. Okay. And, the father is determined to be the guy who lives in her house. Well, there you go.
But
Other,
it's interesting. I mean, you have to really think through everything. And again, and I've said this to you before, but this stuff is really complicated.
oh, it is. Yeah. We, but generally, so,
Yeah.
how long do people collect this?
Yeah.
Sometimes widows will collect, for 5 or 10 years before they settle it. They can settle it because, you can imagine if an insurance company is faced with paying indefinitely or just sitting around waiting for someone to get married, they'd rather just get it over with and give
Sure.
them money. And the question is, how much are they going to give them? So that's where we come in, and that's where the skill comes in. I've settled widow cases where the woman is 50 and has been on it for 10 years. I settled one for a 23-year-old who was only on it for 6 months, but she had a 3-year-old child. She wanted to get a lump sum of money and buy a house. It worked out for her.
Wow.
So these cases are all different.
Yeah.
And
Yeah.
and it's interesting too because they can settle for a very large amount of money. In fact, usually they're the largest settlements because especially with a younger person, the prospects of paying for 30 years go, it could be $1 million that the insurance company is faced with paying,
Yeah.
or they could settle it now. And I
Yeah.
just had one last year that I litigated successfully where we had to first prove that they were married because they were only common law married. Now,
Okay.
in 2005, the Pennsylvania legislature outlawed common law marriage for all purposes. So, in this case, they had become common law married before 2005. In fact, for 30 years, they lived together as husband and wife. So, the law still allowed us to show a common law marriage that was consummated prior to the act of 2005. And therefore, once we proved that, we could then have the widow collect workers' comp benefits. And it was a lot of money involved. They had denied the claim from the beginning because there was no marriage certificate. She went from getting nothing to getting a lot of money, and it worked out really good for her.
That is really interesting. And, I mean, just to think through these things, I think you really need an attorney to think through this. Nobody could navigate this. Nobody could figure this out on their own. Did you litigate that one?
I did.
Okay.
It was just last year, and the attorney who referred it to me, because we have a lot of attorneys who don't do workers' comp,
Yeah.
they refer it to us. Just like a doctor sends you to a specialist.
Sure.
It's the same thing. So they send us the cases, and we had a discussion. He said, when she first came to me, she had no idea she might be entitled to hundreds of thousands of dollars.
Yeah.
And look, here we are a year and a half later, and she has it in the bank.
That's great.
It did work out.
That's
for
great.
sure. Yeah.
Yeah. Bill, what about amputation and scarring? What kind of benefits are there when that happens on the job?
Right. Again, another provision of the Workers' Comp Act that provides for the unfortunate reality is that people get things cut off.
Yeah.
So, but it's limited. And it's limited in a couple different ways. Again, I'm going to talk about how this is unfair because that's what I do, if you've noticed. So people, obviously, hands, fingers, arms, legs, feet, these are the limbs that are provided for. So there's a schedule, there's a graph.
Okay.
That shows you if you lose one half of this finger, you get X.
Wow.
But that X is not a dollar number. It's weeks. So, for instance, one half of a finger, and different fingers you get different amounts for.
That's amazing.
Yeah, because the index finger is more important. So you get more for that. The thumb is the most important. You get the most for that. So anyway, say you're going to get 40 weeks for half a finger. It's paid in weeks. So what does that mean? That means they have to go through the process of, like I said in the past, scheduling or calculating the average weekly wage, coming up with a compensation rate, multiplying it by the number of weeks provided for in the Act. So if it's $300 a week is your compensation rate, then you get 40 weeks. There you go, $12,000.
Okay.
And that's all you're going to get. Now, obviously, what that means is if you're an individual who makes a high wage, your finger is worth more. Yeah. I don't, for the life of me, I don't understand how that's fair. So if you work in an entry-level job right out of high school and you're making $7.85 an hour and you get your entire hand cut off, you're going to get, whatever, $20,000, $30,000. If you're a 50-year-old person and you're making $37 an hour, you're going to get $150,000 for that same hand.
You're right. Not fair at all.
It isn't. But what the legislature will say, and what the history of it is that, hey, this is a wage loss act. This is about how injuries affect your right or ability to work. So you don't have a hand now. Certain jobs you're just not going to be able to do. We're going to pay you in weeks because that's affected your income.
Yeah.
Again, it's not about pain and suffering, so I understand that. But I think it should be across the board the same. A hand is a hand is a hand.
Yeah.
Anyway.
Yeah.
So, but
what about if the? Go ahead. Were you going to say something there?
No, go ahead.
What about if the worker contracts some kind of a occupational disease?
Oh, Okay. Well, before we get into that, why don't we talk about scarring?
Oh, yeah, right. Go
Right.
ahead.
There is provisions for occupational disease. It's a whole different thing. But
Okay.
in the same part of the act that provides for amputation, there's also provisions for scarring. So people, again, they get scarred, they get burnt,
Yeah.
they get cut, all kinds of things. But it's limited to scars that are above the clavicle. Again, for the life of me, I can't understand why this is. So
That's interesting.
we're talking head and neck, face.
Yeah.
That's all we're talking.
Okay.
And I've had a lot of people who have terrible scars on their hands
Yeah.
or their body, and particularly young women, if they want to go to the beach or whatever, a lot of their body's visible. So a
Right.
big scar on their leg or their stomach may be visible. They get nothing for that. I
Oh,
guess the theory is it doesn't affect your ability to work. I don't know how a scar on your neck really affects your ability to work either,
yeah.
but that's what we're faced with. And
Okay.
again, scarring, there's no schedule because obviously every scar looks different.
Right.
So it's purely subjective. The
Okay.
judge will look at you and make a determination about how bad it is, make an award in, again, weeks. Again, another really unfair thing.
Okay.
So if you're that entry level worker, and you have a terrible scar on your cheek,
Yeah.
it's going to be worth less. But why should it be?
Right.
It will be. It'll be based on your average weekly wage and your compensation rate. And
Right.
I think judges should take this into account, but I've noticed that they don't all do this.
Yeah.
So, I had a woman who she got hurt. It was a part-time job. If it's a part-time job, your comp rate's going to be very low.
Yeah.
And she has a terrible scar on her neck. And he gave her like 25 weeks, which may have been okay if she was a high wage earner working a full-time job, which she
Yeah.
wasn't. So
Yeah.
she got only a few $1,000s for something that's permanent.
Oh
And
my.
but judges, some are
Yeah.
more liberal than others in
Yeah.
regard to giving away benefits.
Yeah.
But this is, I mean, this is an art. This putting, in controversy these injuries and these
Yeah.
scars, because you can get it for teeth knocked out, anything that's disfiguring.
Okay.
Because your attorney has to recognize it
Yeah.
and bring the issue to court.
Wow.
Mhm. So anyway, you wanted to know about
Occupational
occupational
disease.
disease.
Yeah.
Now, in the Pennsylvania Workers' Compensation Act, there are provisions obviously for injuries and for specific enumerated diseases. And there's also a catch-all, and I'll explain that in a minute.
Okay.
But anything that is an disease caused by work could also be an injury.
Mm-hmm.
When I say that, I mean there are different provisions of the act you can litigate under. So you could litigate a disease under the injury portion of the act if you wanted to. So let me explain this in more detail. So the act says if you get these diseases, all you have to prove is that you were exposed to the hazard of this disease in your work. The more common ones are co-workers pneumoconiosis, which is black lung, silicosis,
Yeah.
which a lot of people in steel mills get, or if they work in a brick factory or anywhere where there's silica. Beryllium poisoning is enumerated. There's a specific act on cancer in firefighters, and this is a
Okay.
fairly new thing,
Oh.
where it is what we call a rebuttable presumption. Now, that's a legal term, but it's a rebuttable presumption that if you were a firefighter and you were exposed to fires, and if you get cancer, it's related.
Okay.
A rebuttable presumption just means the stricken firefighter just need to come into court and show that he was exposed as a firefighter. And then the defendant, the insurance company, can rebut it or contest it by having exams, taking of history. Obviously, if someone smoked or there are issues with various causes. But For any of the enumerated diseases, you can just name them and just show that you were exposed and you have it and you win, assuming there's not a legitimate defense.
Yeah.
One of the enumerated diseases is tuberculosis. I'm currently litigating a tuberculosis case. And it's just tricky because, like a lot of tuberculosis, it's a real problem in nursing homes.
Okay.
So most nursing homes have
Yeah.
protocols where they're testing the residents and they're testing the workers on at least an annual basis
Yeah.
to see that they're not getting it. Because once tuberculosis gets into a nursing home, it apparently spreads like wildfire. So
Yeah.
I have a young nurse trainee who comes to me and says she has tuberculosis and she believes she got it at work, which was a
Yeah.
nursing home. Now I have to prove that somebody at the nursing home gave it to her. And the thing about like a lot of these viruses and stuff, they're in the air. You can't see them. They're
Yeah.
invisible. We
Right.
don't know when we walk into something infectious in our lives. It could be anywhere.
Yeah.
So I have to prove it was at work. It's not a small order, but the other problem is this, that we encountered. We realized that it might be difficult for us to find out if a particular resident has tuberculosis because that particular resident's medical history may be confidential and protected by the HIPAA Act.
Oh, wow.
So we've had to do some litigating to prove
Wow.
this.
Yeah.
And it's a very interesting case, but I took it because I realized tuberculosis is a lifetime disease.
Mm.
This girl's the girl's
Oh.
21 years old.
Oh,
So
my.
she's going to have it the rest of her life.
Yeah.
Now,
Oh.
whether it becomes active is the question. Once it becomes active, then you're sick.
Yeah.
When it's dormant, you can function and you're not
Okay.
even, she tells us she's not even contagious right now. Anyway,
Wow. So that's a case that you're working on right now.
correct.
Okay.
And those are, I'm sorry, those are an
I was going to
example
say,
of some of the disease cases that are listed in the act.
yeah. I was going to ask you do you actually seek out the most challenging cases? Because all the ones you're telling me about, it's like they're so complicated and so challenging. I think you
I'm only
like it.
talking. I'm only talking about the interesting ones because
Okay.
we're on TV and I don't want to be boring.
Right.
But it's true that if you're a senior attorney, as I am, and you're
Yeah.
certified, and you're a specialist, that's what you want. You want the cases that have high stakes, high difficulty, because the easier, more routine matters can be handled by people who are in the process of training themselves
Yeah.
to be a workers' comp attorney.
Yeah. Yeah.
I also interesting. This is we're litigating it as an injury, but I have a Lyme disease case right now.
Mm-hmm.
So the individual definitely has Lyme disease. Definitely was able to testify that in the course and scope of his employment, when he was clearing brush in a cemetery, he got a lot of ticks on him. So when he left work, he looked down, they were everywhere on his arms and whatnot.
Oh, my.
And then when he got tested weeks later, sure enough, he had it. Again, Lyme disease. It's a lifelong event.
Oh.
So he comes to me, and he's not disabled at this point, but it needs to be established where that came from, so he has lifetime protection
Yes.
and medical coverage. So anyway, we're currently litigating that one.
Wow.
I expect a favorable result in that. The
Good.
evidence is pretty clear.
Excellent.
But see,
Excellent.
the reason we're not litigating that is an occupational disease is this. The occupational disease provisions of the Act say that if it's not on the list, i.e. enumerated, you have to show that that disease occurs in a higher incidence in that particular profession than others.
I see.
A lot of times you can't show that. In
Yeah.
this case, excuse me, there's nothing about Lyme disease that is common in this guy's profession. He just happened to be wrong place, wrong time.
Right. Right.
So we're not going to be able to show that. All we're going to show is that it's an injury and it occurred during the course and scope of his employment.
Yeah.
Again,
Yeah.
another interesting case.
Were you going to tell me another interesting one, or we?
No, that was another one, the
Oh,
Lyme
yeah,
disease
that
case.
was very interesting. Well, let
There are
me ask.
others, but
Let
I don't
me
want to
ask.
go on forever, you know?
No, no. I
You
was going
know.
to ask you about current developments in the law because you're very up on this stuff.
Sure,
What kinds of
sure.
things are happening in the law now?
Um, I was reading some cases recently, and I came across this one that I thought was very interesting. And it's what we would call a case of first impression. In other words, it's never been decided before.
Okay.
So there was this case where a roofer is up on the roof, and at the end of the day, he didn't realize, but everybody had left but him. And he's on the roof, and they took the ladder. Right. So
Word.
he's on the, and he decides, and I don't look at it, it must be a young person, because only a young person would do this. He decided, well, I can probably jump from this roof.
Oh my
I'll
goodness.
just go to the lowest part and I'll jump. He does, and of course he gets injured, and of course they defend it. They don't want to pay him. They're saying you intentionally hurt yourself. So obviously, if there was a situation where, and we just discussed this today, you intentionally hurt yourself on the job, you're not going to
Yes.
get benefits. And the court found that he wasn't trying to intentionally hurt himself. He was just trying to get down from the darn roof.
Good.
So he got benefits, but not without some litigation. I thought that was an interesting
That
case
is very interesting.
because, you know, they can defend these cases based on another theory they call violation of a positive work order. So if I'm say I employed that guy
Yeah.
and I said, okay, at the end of the day, you must use a ladder. If you jump off this roof, we're not responsible. You get that? What did I just say? Must use ladder. Okay. So that's a positive work order.
Okay.
It didn't happen in this
Right.
case. If it did, they could defend it saying, but
Oh my goodness.
I told you not to jump off a roof. I think you would know that being a grown up. Anyway, one of the things I have access to because one of our attorneys is a member of the Pennsylvania State House of Representatives. So I use his office to keep me abreast of developments in the law, proposed bills, what's being discussed in committee, things like that. So it's
Excellent.
very valuable to me
Yeah.
to have him here. Anyway, so I got some memos on some of the things that are going on. Representative Ryan McKenzie, who is uh, apparently very solicitous of insurance companies, is pursuing this evidence-based, and I've talked about this before, evidence-based medicine where doctors are no longer free in a workers' comp setting to just prescribe. There's going to be a chart. There's going to be a graph. It's going to tell them what you get, how much you get, for what condition you're treating, and no discretion from the judges. So this year he's reviving that. It's not passed yet, but this particular representative is still pushing that.
Okay.
It's not the law yet.
Yeah.
Uh, Now, there's another Senator Gordner of Pennsylvania is interested in legislation to help the uninsured employers guarantee fund, which I had mentioned before, because I think what I mentioned before was often we find they don't have enough money. So
Right.
they're contesting everything because they can't just settle it and pay it. Now, one of the ways he's trying to fix that is not to give them more money, but to make it more difficult to go against them, to put limits on it. So again, I don't think this is good for injured workers,
Right.
but the problem with uninsured employers is constant. Now, I don't think every state has this because if in some states you get hurt and you don't have any insurance, your employer doesn't, I think you're out of luck. But not in Pennsylvania. At least we have something.
Yeah.
Anyway, so
It seems like there should be harsh penalties for that.
absolutely, and there are. We were talking about previously some of the prosecutions for not having insurance.
Yeah.
Usually a misdemeanor, sometimes the felony, depending on the
Wow.
amount of money involved.
Okay.
What we find, though, is these people don't usually go to jail unless
Yeah.
they're multiple offenders. What we see is they get probation plus a big order of restitution against them because,
Okay.
well, to make the injured worker whole
Sure.
is the main
Yeah.
point of
Yeah.
all that. So, in November of 17, Representative Ed Gainey said that he planned to introduce legislation to change those death provisions in the Pennsylvania Workers' Compensation Act that we were just discussing.
Yeah.
I was talking to you about how when a widow may get remarried, she may be entitled to the dowry of 104 weeks
Yeah.
in a lump sum. However, this particular representative, and I think he's right, thought that that was unfair for people who die as a first responder. So he's introducing this bill that if you die in the course and scope of your employment as a first responder, police, fire, ambulance, your widow can remarry and continue to collect her benefit.
Okay.
And he analogizes this to pensions.
Yeah.
Your spouse dies in the course and scope of his employment, and you're on his pension. You don't lose that just because you got
Right.
married.
Yeah.
It was earned.
Right.
So he wants to make it similar to the pension.
Yeah.
Anyway, so that's not yet, I don't think, even introduced.
Well, bravo to the people that champion these kinds of causes, because without those champions, change wouldn't happen.
Right. And I think an open-minded representative will let people bring him ideas.
Yeah.
So I'm sure there's some, the FOP or the Firemen's Association brought it to his attention that they're risking their lives, for God's sakes,
That's
more
good.
so than most people.
Sure.
And when they lose their life, the widow shouldn't suffer. She
I
should
agree.
be fixed for life
Yeah.
because if you give your life in the service of others, your family should be taken care of.
Yes, absolutely.
Absolutely. So there's another interesting bill that's being proposed by Representative Patrick Harkins. And he thinks that there is no protection for workplace bullying. Now, bullying is something we hear about in the schools, but how
Right.
often do we hear about it in the work?
Yeah.
But trust me, from representing people who were injured at work for years, I can tell you it's a real thing. And that people do act like children against other people in the workplace, and it causes them to go crazy and to be unable to work, to quit, to feel like, they're being harassed.
Yeah.
Whatever. So he's introducing something to allow you to sue under the Pennsylvania Human Relations Act for this bullying. This kind of crosses over with workers' comp, too, because bullying could result in a mental disability.
Yes.
I've had people tell me, I can't go back in there. I'm like, I can't leave my house because the thought of going back in there with those people is just nerve-wracking, whatever.
I think that sounds like great legislation and very necessary. Nobody should have to suffer under bullying.
Right. And in his memo, the representative points out that bullying causes stress-related diseases, hypertension, autoimmune disorders, PTSD, whatever, and
Right.
it's a real problem.
Yeah.
Then it becomes, say, for instance, it becomes a work injury. Well, you have that. But again, we've talked about how hard that is to prove.
Yeah.
So sometimes they need to just sue and get some kind of recovery for their pain.
Yeah.
Anyway, Harkins is looking at
Interesting.
that. Mm-hmm. And there's another issue. A few years ago, the Commonwealth passed what is called the Construction Workers Misclassification Act. What they were doing was basically codifying, and when we say codifying, I mean making it a law, what had already been decided over the years in various cases. And that was, if you were an independent contractor, you were not entitled to benefits from your employer's insurance carrier. You have to be an employee. So what is an independent contractor as opposed to an employee has been the question.
Yeah.
And there are numerous cases. Sometimes it's easier just to put down the rules in a statute That's what they did. So there's another way to deal with that too, and I know other states have done this, and it's called registration of independent contractors.
Okay.
So if you say you're a truck driver or you're a subcontractor in construction or whatever, and maybe you have your own insurance or whatever, maybe you don't care if you have coverage or whatever, you just want to work.
Yeah.
You can register as an independent contractor, and that's like admitting before you ever even get hurt that you are independent. So you do that, you're basically waiving your right
Yeah.
to file a comp claim if you get hurt,
Yeah.
regardless of the circumstances. Because
Okay.
for some people who employers want to say, well, you're an independent contractor, when they're really not. It's just an employer trying to avoid
Yeah.
liability. So,
Yeah.
but this registry would allow people to do it. Now, most of us who represent people are against this kind of thing. Because
Yeah.
what we believe is that most of them will enter into this registry without legal advice.
Yeah.
They're just trying to make a dollar. And they
Right.
know that the only way to earn a living in this particular profession is if they admit they're independent, therefore they can get to work.
Yeah.
So, if they seek out legal advice, we would probably tell them this is not a good idea.
Yeah.
This will not protect you in the event of injury or death.
Yeah.
So anyway,
Yeah.
but that's on the table. Again, that's sort of an anti-worker bill,
Yes.
I would say.
Yes.
I would say.
Yeah.
So the final one is Senator Fulmer, and I don't know the status of this right now, but he had tried this before and he wanted to do it again because there was a Pennsylvania workers' comp case where someone successfully sued a parent company. So you get hurt by a subsidiary. You can't sue that subsidiary because they have what's called statutory immunity under the Workers' Comp Act. You can't sue your employer.
Yeah.
If you could, all chaos would reign. And
Yeah.
so they just set up a system where you get these benefits and that's all you get. They sued the parent company because they're saying it wasn't my employer, and they won. Therefore, the proposed legislation by Senator Mike Fulmer is to reverse that. So you can't sue the parent company. I don't know
Okay.
where it is right now, but I know it hasn't been enacted.
Yeah.
So that's about all I have for new
Very
and
interesting.
interesting things. Yeah.
I love that you are on top of all this. It's really interesting. And again, I think that anyone who's listening that has either had a work injury is already even if they're already collecting workers' compensation, it makes sense to check in with some of these things because it just seems to be constantly changing and evolving. So that
That's
I
so
would
true.
imagine the status of some of these injured workers could change over time.
You could.
Yeah.
There's no reason not to protect yourself. You should
Yeah,
always have an
yeah.
attorney.
Well, Bill, if someone has questions, what's the best way to reach your office?
We have an 800 number. It's 1-800-518-4LAW. That's the number 4, LAW. Locally, it's 570-874-3300. You call and tell them your problem. They'll give you somebody to talk to. Hopefully, you'll end up talking to me or Deb about your comp case quickly.
Excellent. Excellent. Well, I look forward to the next time we talk.
Okay.
And
Thanks, Cindy.
Thanks so much for your time.
All right. I'll see you. Bye-bye.
Okay, and those of you that are watching, thank you for being with us today. You can leave your questions or comments right on this page, and we'll make sure they get answered. Bye, everybody.